a bridge for justice. And therefore, in the administration of justice, the role of the advocate and judges is very much important. The student must aware regarding the rules of Bar Council of India, the professional ethics and the laws enacted by the Parliament and the state legislature. While studying the law, student must aware the practical knowledge before entering into actual practice as an advocate. It is very much essential to know the process and procedure, legal procedure, to conduct the cases in civil division and criminal division. If the practical training while taking a law education is not acquired, there is a waiting period for the students to know the practice in law. It is a mandate in legal process. The law is one thing and law in practice is another thing. That is why, in the interest of justice, from the phase of beginning, the student must know the process and procedure of law courts. The Bar Council of India, through their universities and colleges, have prescribed the syllabus for the students to make aware themselves the process and procedure of the court of law. For LLB third semester, 3-year degree course, and LLB 7th semester, 5-year degree course, the Bar Council of India has prescribed the contents of syllabus by providing a subject of moot court. The actual trial, the application of law, that is a Criminal Procedure Code, Indian Penal Code, Indian Evidence Act, CPC and other related laws in civil factors, are Dr. Prakash Davade, Associate Professor, Dr. Punjabrao Deshmukh College of Law, Amaravati, since 1997, has provided the platform to the student through the syllabus and the practical training to the law student through the moot court. In place of moot court, I have adopted the mock courts in which the students may acquire the knowledge of the law and law in practice. This knowledge is not only for the examination purposes, but also for the student in law practice as well as to acquire the post of judicial magistrate first class. Whenever our students selected and appointed as a judge in lower division, that is the judicial magistrate first class and civil judge junior division, they may handle their dais court properly. The judges, the main role of the judges to pass an interim orders, to give certain dictations in the trial, that is to say depositions, in the language of the court of law. The student must know the entire process which is adopted by the court of law from the stage of appearance of an accused till the disposal of the trial. How to behave in the court of law, because the advocates are the officers of the court, and therefore the advocate must maintain the discipline, decorum in the court of law. They should pay respect to the court of law, to the chair of the judge, to avoid the contempt of court. And therefore, by acquiring the various provisions of law, the law student must aware about the discipline and convincing power, because acquiring the knowledge is not enough. The student must aware how to maintain the discipline, how to apply the legal language, how to maintain the decorum in the court of law, and how to place the case before the court, how to cross-examine the witnesses, and how to argue before the court. Because it is an ample duty to provide the justice to the litigants or the client. Because Bar Council has provided us the professional ethics, and therefore we must aware regarding the duties and rights as provided under the Advocate Act 1961. It is my humble request to all the students to go through the practical training of such moot court, which is very important in our career, not only for examination, for your entire life in the law practice or while acquiring the chair of the justice. Therefore, the students may take the benefit of such education, which is very important in the universe, and I am hopeful from all the students who may take the benefits of such mock course in the form of a moot court training. And the video which is uploaded here, our student must see and act accordingly. Thank you.
Number one, the extrajudicial condition is weekendless and it is only for corroboration. Number two, the recovery of dead body is doubtful. Number three, the statement of the mother is found doubtful. I have also observed the authorities relied upon by the defense in Chandan Singh versus State of Rajasthan and Sita Ramchandri versus State of Maharashtra on the point of extrajudicial condition is weekendless. It is a matter of justice, and I have with the eyes of justice observed the evidence, law, authorities, presumptions, circumstantial evidence, and indication of accused, and the chemical analysis report. It is the relevant values of the justice and found in favor of the prosecution. Therefore, I have no hesitation to pass these following orders. Number one, the accused Mr. Rama Prasade, Datta Priya Gargi, and Santosh Mandewar are hereby convicted for an offence punishable under section 302, 201 and 34 of IPC and sentenced to death. Number 2. The death sentence is confirmation case. The death sentence is confirmation case by the order of Honorable High Court. Number 3. The certified copy of the judgment be delivered to all the accused with free of cost for the purpose of filing appeal. Number 4. The jail authorities are hereby directed to keep the accused person in jail at very sensitive place and observe till their death row is confirmed by the Honorable High Court and the Supreme Court. Number 5. The death sentence be executed after the positive verdict of the Honorable High Court and the Supreme Court. If the mercy petition is rejected by the President of India, then execution of death sentence may be followed process and procedure of section 354, subsection 5 of CRPC, by ending in executing the death of the accused person. Number 6. The judgment is delivered and pronounced in open court under section 353, subsection 1 of CRPC. Now the court is...
That's number 4 will read.
Number 3 of 2009 is for details of
स्वाती अपनी कौन वाली मानी होती है स्वाती को काय प्रॉब्लेम हो वाली शिक्षण में कोणत्या प्रकारात आपल्या आक्षेपारे मजकूर आपण मेरी आवाज को या सूत्रात बनवली आहे आपल्या मुलीबाबत वृत्तपत्रामध्ये कोणता आक्षेपारे मजकूर आपण माझ्या मुलीचे लग्न झालेले असताना सुद्धा तुला देव होत आहे अशा प्रकारचे कोणते आक्षेप
Marriage was not arranged, even though media was seen in newspaper published that the marriage ceremony is solemnized in Ekira Devi Kondakara and Amravati.
सदर आक्षेपाने मजकूर सापडल्यामुळे त्याचा परिणाम आपल्या मुलीवर आपल्यावर कसा पडला सदर वृत्तामुळे माझ्या मुलीला मला कुटुंब संबंधितांना खूप वाईट वाटते तसेच माझ्या मनावर तिच्या भविष्यावर दुष्परिणाम
My daughter depends in the eyes of society. Here my article was and my daughter led into depression as her image rolled down in the society and her future injured.
स्वातीने कशाचा दावा दाखल केला माझ्या मुलीने तिच्या जन्मानुसार तज्ञांनी झाल्यामुळे नुकसान भरपाईमध्ये 10 लाख तुझा
My daughter depends in the eyes of society. Now, therefore, she claimed this 10 lakh is for compensation of damage.
वादीचा दावा कसा आहे वादीचा दावा खरा व वास्तव आहे पण मंजूर होण्यास
just proper and matter for cost of damage.
Your Honor, magic examination is over.
You may take it. Yes, Mr. Counsel of Defendant, cross-examine the witness.
Yes, sir. हे तर बरोबर आहे प्रतिवादी तुमच्यासोबत तुमच्या मुलीसोबत मुलगी दिसलेली आहे बरोबर आहे
It is correct to say that there is humanity of defendant with me and my daughter.
हे तर बरोबर आहे प्रतिवादीने त्याची जाहीर माफी मागली बरोबर आहे
It is correct to say that even apology was made by defendant to his publication.
हे तर बरोबर आहे कुठे आहे
कुठे
It is not correct to say that the suit of a plaintiff is false.
आमचे असे म्हणणे आहे की तुम्ही सांगितले
कुठे
It is not correct to say that I am deposing false.
Your Honor, my cross examination is over.
You may take it.
Thank you.
Yes, Mr. Counsel of Plaintiff, do you want to examine any witness in support of your side?
No, Your Honor. We have examined almost witnesses in support of our case. Today, we do not want to examine any witness in support of our side. Therefore, I am filing this procedure.
Yes, Mr. Counsel of Defendant, do you want to examine any witness in support of your case?
No, Your Honor. The defendant side has examined all the witnesses in support of the case. Now we do not want to examine any more witnesses. Therefore, I am filing this process.
Both the parties have closed their side. Now the case is posted for recording argument. Yes, Mr. Counsel of Plaintiff, present your argument.
May it please Your Honor. The present suit is brought up by the plaintiff for compensation of damages. In the present case, the plaintiff girl has defamed by the wrong use of this regarding her wedding with false and defamatory motive. In Mary Abbas daily newspaper, the contention that the marriage of the girl is going to solemnize at Ekira Devi Kondakara and Amravati. But in fact, somebody has tried to defame the girl and the defendant has not taken any action to verify the news before the publication. The plaintiff has proved the contentions of the pleading as well as evidence brought up before, and thereby the facets of section 19 of Civil Procedural Code are well founded. Therefore, the compensation of rupees 10 lakhs may be solved for the purpose of justice. It is solved for the purpose of justice. It is further contended that the daily newspaper of Mary Abbas has already admitted the wrong publication in his evidence, and they have made an apology. But such contentions have no sanction of the rule of law when the girl is already great in the eyes of society, where application is separated. Therefore, it is common here to always quote, the suit of the plaintiff may kindly be decreed with cause. That's all, Your Honor.
Yes, Mr. Counsel of Defendant, present your argument.
Yes, Your Honor. The suit of the plaintiff is baseless and has no substance at all. The media and a newspaper is working as a social worker for the benefit of the society. The media is a well-wisher, supporter, and a close friend of the society. And the freedom of the press is enshrined by the Indian Constitution, and it's a basic fundamental right. No doubt, the news publications in the newspaper media are asked to defend the image of the girl in the society and in the public at large. But the defendant has a trust both the society and if the deposit represent amount from the person who want to public the wedding ceremony and advertisement. In the circumstances, the circumstances showed that the defendant had no qualified intention to defend the girl, and therefore the suit brought up by the plaintiff has no legal sanction, and it is not to the court of law to dismiss the suit in the interest of justice. That's all. Thank you.
I get both the side of parties. Now the case is posted for recording judgment. I get both the sides. I have personally pleaded on both the parties. I will issue and party the evidence. I also observed the news item published in media newspaper, the circulation amongst the friends, people, and relatives, and the community is found to be injurious. The rule of law is protected under law of law. Of course, law of law is law of law, which is incorporated within the mandate of Civil Procedural Code 1908. On the other hand, defendant tried to prove that publication of news against the girl is not with malafide intention, even apologies made by defendant through its publication. Therefore, they pray to dismiss the suit. I have applied the principle of justice which are important in civil law. Number 1, balance of convenience. Number 2, prima facie evidence. Number 3, irreparable of evidence. This principle are squarely applicable in favor of plaintiff. There is no malafide intention in the case, but the publication is wrong, which is covered under the state of law, which is not excusable. In these circumstances, I have no hesitation to pass the following orders. Number 1, the suit of plaintiff is hereby decreed with cost. Number 2, the defendant does have to pay rupees 7 lakh for compensation from the date of suit by 8% interest. Number 3, decree drawn up accordingly. Now the court is retired.
Wherever the court of forward, Tejas Dange, Suyog Mathurkar and Dikshita Buri, then wherever